The Supreme Court just dropped a 6-3 emergency ruling that did not change the Second Amendment text by one word, but it may change how gun rights cases are won or lost from this day forward. And if you think this is only about immigration, that mistake could leave you totally unprepared the next time a gun ban, carry restriction, or ATF rule gets challenged in court. Quick question before we continue. Are you subscribed? Because the biggest legal mistakes happen when people hear the headline, skip the details, and assume nothing affects them. Hit that subscribe button right now, because what I'm about to explain could change how you look at every major gun case from here on out. Here's what just happened. The case is called Trump versus CASA. On June 27th, 2025, the Supreme Court ruled 6-3 that lower federal courts usually cannot issue those giant nationwide orders people call universal injunctions. That means one district judge usually cannot stop a federal policy for everybody in America with one stroke of the pen. Now, this is where it gets interesting. The court did not decide whether the birthright citizenship order in that case was legal or illegal. That part is still being fought over. What the court decided was something more structural. It decided who gets protected when a lower court blocks a government action. Before this ruling, many people believed that if one federal judge found a rule likely unlawful, that judge could shut it down across the whole country. After this ruling, the Supreme Court said, not so fast. In most cases, relief should be limited to the actual people, groups, or states who sued, unless there is some other legal path to broader protection. Let me break that down for you in plain English. Imagine the federal government announces a new gun restriction tomorrow. Maybe it targets a popular accessory. Maybe it changes how a background check rule works. Maybe it redefines who can buy what and where. Before this ruling, gun rights lawyers might race into one friendly federal court, win an early order, and argue that the rule should be blocked for everyone nationwide. But here's the crazy part. After this 6-3 ruling, that strategy just got weaker. A judge may still protect the people who actually filed the case. A judge may still protect a state if that state proves it needs broader relief. A judge may still protect a certified class. But the easy version of one judge blocks it for everybody is now in serious trouble. That is a massive shift. Not because gun owners suddenly lost every case, and not because anti-gun states suddenly won everything. It is massive because the battlefield changed. Most people think gun cases are only about the Second Amendment. The truth is, they are also about procedure. Who can sue, where they can sue, how fast they can sue, and most important, who gets immediate protection while the case drags on for months or years. And that waiting period matters more than people realize. A bad law that stays in effect during a lawsuit is still a real law. You can still be arrested under it. You can still be charged under it. You can still lose your rights fighting it. Even if the law gets struck down later, the damage in the meantime can be huge. That is why this ruling matters so much to gun owners. It is not really about one immigration order. It is about whether future gun restrictions can be frozen quickly for the whole country, or whether regular people will have to wait while narrower lawsuits crawl through the system. And there is one more detail you need to know. The court said the order in that case would not take effect for 30 days, giving lower courts time to adjust. That tells you the justices knew this was a big procedural shift. They were not just deciding a small technical point. They were redrawing the rules of the game. If you're finding this helpful, imagine what you'll learn in my next video about the exact legal words that matter when an officer asks questions during a firearm stop. Subscribe now so you don't miss it, because the people who stay informed make better decisions under pressure. Now let me explain why this matters to your world, even if you never read a Supreme Court opinion in your life. Think back to New York after the Bruen decision. In 2022, the Supreme Court said New York's old proper cause carry system violated the Second Amendment. A lot of gun owners heard that and thought, great, problem solved. But then New York came back with a new law, the Concealed Carry Improvement Act, and stacked it with new restrictions, sensitive place bans, training demands, and other limits. Gun owners challenged that law right away. A district judge blocked big parts of it. Sounds like a win, right? Not so fast. On emergency review, higher courts stepped in, and in January 2023, the Supreme Court allowed New York to keep enforcing that law while the litigation continued. Let that sink in. People heard "we're suing" and assumed protection was immediate. It wasn't. The law stayed active while the fight kept going. Now picture Illinois. Challengers asked the Supreme Court to temporarily block that state's ban on assault-style weapons while the case moved forward. In December 2023, the justices refused to step in. Again, that does not mean the challengers ultimately lose forever. It means the restriction stays in place while the legal machine keeps turning. Here's what most people get wrong. They think the final decision is the whole story. It's not. The temporary stage can be everything. If the law remains active during the fight, that can shape behavior, sales, possession, travel, training, self-defense planning, and your risk level long before the final opinion ever arrives. So when this new 6-3 emergency ruling says lower courts usually cannot block federal policies for everyone at once, gun owners should hear a loud warning bell. Because the next time a federal firearm rule gets challenged, the question may not be just, is this constitutional? The real first question may be, who exactly is protected while the case is pending? That changes strategy in a huge way. Maybe you are protected because you are a named plaintiff. Maybe you are protected because you live in a state that sued. Maybe you are protected because you are part of a certified class. Maybe you are protected because you belong to a specific gun rights organization included in the case. Or maybe you are not protected at all, even though you support the lawsuit and think the rule is obviously illegal. That last part is the one nobody's talking about enough. Here's a hypothetical example to explain this. Let's say a new federal rule targets a certain kind of rifle accessory. Group A files suit in Texas. They win an early injunction. Before this Supreme Court ruling, people across America might hope that order blocks the rule for everyone. After this ruling, the safer assumption is narrower. The protection may apply only to the actual plaintiffs, maybe their members, maybe their customers, depending on how the order is written. So if you're sitting in another state saying, "I saw on YouTube that a judge blocked the rule," be careful. That may be true for some people and false for you. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. And that warning is not just lawyer talk. It's practical survival advice. Because when the law gets messy, bad assumptions are dangerous. Hey, 73% of people watching videos like this are not subscribed. Don't be part of that group. Join the community of gun owners who want the details, not just the drama. Click subscribe now because these court fights move fast and the headlines almost always leave out the part that can hurt you. Now let's talk about what smart gun owners should watch next, because this is where the story gets even more important. The Supreme Court did not say broad protection is impossible. It said the usual nationwide injunction from one lower court is usually not the right tool. That means lawyers are already looking for other paths. First, class actions may become much more important. If a court certifies a class, that can potentially protect a much larger group of people. So in future gun cases, you may hear lawyers push hard to build a class instead of relying on one person's lawsuit. Second, membership could matter more. Some recent gun cases have already shown courts sometimes extend relief beyond just one named person. In some cases, judges have protected members of organizations and even certain related people or customers. Translation: who you are connected to may matter more than ever. Third, lawsuits by states could become even more powerful. If a state is the plaintiff, the court may find broader relief is needed to fully protect that state. So when you see red states or blue states jumping into a gun case, do not assume it is political theater. It may be the legal vehicle needed to get wider protection. Fourth, Rules issued by agencies like ATF may trigger another path. In some administrative law cases, courts can set aside an agency rule under the Administrative Procedure Act. In plain English, that can sometimes wipe out the rule more broadly than a normal plaintiff-only injunction would. That means future fights over agency-made gun rules may look different from fights over statutes passed by Congress or state legislatures. But wait, there's something even more important. This ruling may increase confusion for normal people in the short term. Why? Because now you could have a world where one group is protected, another group is not, one state gets relief, another state does not, and the law becomes a patchwork while everyone waits for appellate courts or the Supreme Court to step in again. Imagine you're at a traffic stop and you're relying on a court order you heard about online. Imagine you bought something because a commentator said the rule was blocked. Imagine you traveled across state lines assuming the same protection followed you everywhere. This is exactly how good people walk into bad situations. Most people want one simple answer. Legal reality often gives you three ugly ones instead. So what should you do? Number one, stop trusting the headline alone. If somebody says, the court blocked it, your next question should be, for whom? Number two, pay attention to whether the case involves named plaintiffs, a class, a state, or an organization. That detail is no longer background noise. It may be the whole ball game. Number three, understand the difference between final victory and temporary protection. A case can look promising and still leave you exposed today. Number four, do not assume a Supreme Court ruling in one area stays in one area. This one came out of an immigration fight, but the rule about injunctions reaches far beyond immigration. Gun law channels that ignore this are missing the bigger picture. And number five, if you support litigation groups, start asking better questions. Not just did you sue, ask, who does the order protect, where, for how long, and what happens on appeal? That is how informed gun owners need to think now. This legal shift is not something you can just learn once and forget. The next major federal gun case could turn on these exact rules about who gets covered and who doesn't. Subscribe right now, because my next breakdown will show you how to tell whether a court order actually protects you or just the people named in the lawsuit. So here's the bottom line. The Supreme Court's 6-3 emergency ruling in Trump versus CASA did not rewrite the Second Amendment, but it may rewrite the playbook for stopping future gun restrictions before they hurt people. The big change is simple. Winning a lawsuit early may no longer protect everyone automatically. That means you need to think more carefully, verify more often, and never assume a court win on your screen equals legal safety in your real life. If you want clear, honest updates without the hype, subscribe now and stay with this channel. And remember, this video is for education only, not personal legal advice. If a rule, charge, or firearm issue affects you directly, talk to a qualified attorney before you act.